Was that an error?
That was an error, Your Worship. He's raising up his hand. If the court allows me to approach him.
Yes, you may.
I get it to the court. Your Worship. As per my instructions, the attorney did phone the state with regard to the date of 27 January 2022 for their absence. And furthermore, my instructions are that on the 10th of February 2022, he went to Johannesburg court. Because when he came here, he was... Yes, sir. When he came in this court, he was sent to Johannesburg court.
And who sent him there? Can you take instructions on who sent him to Johannesburg court?
Thank you, sir.
Because his court case has been in this court.
Thank you, Worship. I really intended to the court, Worship. Worship, on the 27th of January 2022, when my client didn't appear before the court, the investigating officer sent Mr. Mwato the message to say my client didn't appear in court and the matter is being postponed to the 10th of February 2022 for final forfeiture of bail money. And the case has been transferred to Johannesburg Regional Court. So basically it was the IO who informed them that the matter is transferred to Johannesburg Magistrate Court in the Regional Court.
So effectively then, what you're saying, and if I understand you correctly, that his counsel, Advocate Ngwatu, saw it fit to communicate with the investigating officer in this matter to find out the date of the next appearance and the court, and never considered asking the investigating officer or anybody why the matter is now strangely being transferred to the Johannesburg Regional Court when the accused hasn't even completed his appearances in the district court, which is the Hillbrow Magistrate Court, when the matter was not formally transferred to the Johannesburg Regional Court. Is that what you said to this court?
Your Worship, it was not the attorney who initiated the conversation. It is the investigating officer who sent the message to the attorney around 7 minutes before 7 p.m. at night. Then the attorney forwarded the message to the client. It's not. He never. The investigating officer never phoned. He only sent a WhatsApp message.
Yes, so that's what I'm referring to, the communication. The accused counsel relied on communication from the investigating officer, who for some strange reason told him that the matter was transferred to the regional court, not only the district court, because the accused had been appearing in the district court, but the matter was transferred to the regional court in Johannesburg the 10th of February, and the accused counsel was comfortable with that. That's basically the submission.
That is the instructions I got, that the matter was, or he was informed that he must go to regional court, and no reasons were given. And furthermore,
and just before you proceed on that point, in all of this, one of the more important dates is that on the 28th of December 2021, your client personally appeared with Advocate Ngwatu in the Hillbrow Magistrate. And in his presence, together with his counsel's presence, the matter was postponed to the 27th of January 2022, back to the Hillbrow Magistrate's Court, which was this court. And thereafter, your client subsequently did not appear on the 27th of January, and then subsequently on the 10th of February, when the matter was called in this court, he was not present. But following on your submissions, the court would like to know what happened on the 10th of February if you say the accused was notified to go to the Johannesburg Regional Court. What happened on the 10th of February?
In the regional court, Your Worship, he had to go to see Miss Bezedenholt.
Sorry, he had to see who?
He spoke to Miss Bezedenholt.
Yes. In court or in her office?
Because he went to court and to find out whether is he appearing or not. The senior there was Miss Bezedenholt. Then Bezedenholt checked if he is indeed appearing in that court.
Yeah.
His name was not appearing. Then Miss Bezedenholt phoned Hillbrow. He phoned Hillbrow to find out how they could send the client to Joburg court, whereas he's supposed to be in Hillbrow court. Then that is when she told them that the client cannot be at two places at the same time. That's when he left, because his name never appeared in Joburg Magistrate Court.
And what happened since the 10th of February, sir?
Since the 10th of February, Your Worship, if I might just clarify this fact with the client. Mr. Court, this is Osho. I really apologize for taking the court's time. On the day of the 10th of February 2022, my instructions are that Ms. President Holt told him that as he cannot be at two places at the same time, they will keep him updated. The investigating officer, he will phone his attorney. That's my instructions.
Is there anything further you wish to say, sir?
With regard to the issue of the bail amount suggested by the state, Your Worship, we humbly request that the amount be reduced to 4,000 rand if it pleases the court, and the court is amicable to our submissions with regard to the reduction of the bail.
Yes, is that also?
That's all, Your Worship.
Thank you, Mr. Nkabike. Is there any response?
None, Your Worship.
Has the state and the defense agreed on the dates to which this matter should be postponed after the court pronounces on the issue of the release of the accused?
As the court did inform us in the chambers, we are amicable to any day on that week of the 24th.
That's very well. In this matter, the accused, Mr. Teffo, was expected to be at the Hillbrow Magistrate's Court number 2 on the 27th of January 2022. This was a specific order given to the accused on the 28th of December 2021 by my learned sister, Ms. Clear, who was presiding on that particular day in the Hillbrow Magistrate's Court number 2. It will be noted that when the accused appeared in this court on the 28th of December 2021, he was present together with his legal counsel advocate, Mbato. On the 27th of January 2022, when I presided in this court, the accused was not present. Neither was his legal representative present. I'm today advised by his legal representative that the accused was unwell on the 27th of January 2022, and that there was a communication between his legal representative and a prosecutor in the Hillbrow Magistrate's Court. I'm not advised who the prosecutor was. I'm not advised.
Bishop, if I apologize, sorry to interrupt. I did inform advise that is the state prosecutor before the court.
Of the two, that Mr. Peshwa,
The one who's dealing with the matter is not before the court.
Mr. Nkabike.
Yes, yes.
As a result of the accused non-appearance on that day, a warrant of arrest was authorized and it was issued immediately by this court. With respect to the address that I got this morning, and the court be notified that there was a communication between the accused legal counsel and the prosecutor, which, by the way, the court did not receive. In all likelihood, the warrant of arrest would have been held over, pending him recovering from COVID. But that was not done. A warrant of arrest was issued immediately. The accused bail was provisionally cancelled and forfeited to the state. And the case was then postponed to the 10th of February 2022, back to this court for the final forfeiture of the accused bail. On the 10th of February this year, when the matter was recalled in this court, I presided over the matter personally. The accused was absent as well as his legal representative. I'm advised today by the accused attorney that there was a communication between the investigating officer and the accused legal representative, which resulted in him, for some strange reason, being directed to the Johannesburg Regional Court without any knowledge of this court or any order of this court. Today, when the court requested information on what had happened between the 10th of February and today, as this matter appears before this court, I was advised by the accused attorney once again that the accused was advised by one Mr. Seidenholt, who told him that his matter was not in the Johannesburg Regional Court, and that the investigating officer in this matter will call the accused attorney regarding the way forward. In the view of the court, it is surprising that the accused and his counsel would rather follow the instructions of the investigating officer than the orders of the court. Hence, it does not surprise me why the accused says nobody was there on the 10th of February to deal with this matter, because there was no such order by this court in the first place. The starting point for any accused, more especially an accused who has mentioned to this court on numerous occasions that he's an advocate of the High Court, one would expect that they would start and would commence in the court where they were ordered to appear, and not follow instructions by an investigating officer or anybody else who has not made any order to the contrary. Be that as it may, the accused appears before this court today on a warrant of arrest that was authorized and issued against him on the 27th of January this year, which date he was already aware of on the 28th of December of last year. He stands before this court with a warrant of arrest being executed against him. He is technically in custody before this court, and the court has to then make a determination on his release. The prosecutor before this court today, Mr. Nkabinde, has advised the court that the state does not oppose the release of the accused and has suggested bail in the amount of 4,000 rands, 5,000 rands, I beg your pardon. Mr. Tabani has advised the court that the court should consider an amount of 4,000 rands for the release of the accused. The court has to then determine if it is in the interest of justice that the accused be released from custody in this matter to stand the trial that he faces before us. There are various factors that the court must consider, one of which, and importantly, is whether the accused will evade his trial in this matter. It must be said, and is relevant, that the accused who was released on bail in this very matter previously failed to appear in court. A warrant of arrest was authorized and issued against him previously. He was arrested previously. and brought before this court, during which time he was then subsequently released on bail. This is the second occasion on which the accused failed to appear before this court, resulting in him being in custody today. Apart from the issue of whether the accused will stand his trial, there are various other factors that the court has considered and taken into account. More especially, that an accused person is innocent until proven guilty. And as he stands before me, or as he sits himself before me, he is innocent. And that is an important factor in determining whether it is in the interest of justice that the accused be released. Having considered all of these factors, I am of the view that the release of the accused would certainly be in the interest of justice. I am convinced that he will still stand his trial in this matter and should be afforded an opportunity to prepare his defense and to appear in this court and no other court to avoid any confusion until such time he is ordered by this court as to which court he needs to appear in. Having considered the amount of bail that was suggested by the state and having considered the submission by the defense to counter that submission by the state, I'm of the view that in light of the fact that this is the second time that the accused has not appeared in this court, and this is the second time that a warrant of arrest was authorized, issued and executed against the accused, I'm of the view that an amount of 10,000 rands is suitable, reasonable and justified. The bail amount is accordingly then ordered by this court to stand at 10,000 rands.
Please accept.
Start this.
Does the date of 31st of May suit the state and the defense?
It will be suitable to the state, Your Worship.
Suitable. 21st of May.
31 May.
31. It's not suitable, Your Worship.
30?
On that week, it's not suitable. Maybe I was suggesting between the 23rd and the 27th of May.
Could be the 27th. 27th would be more.
Suitable.
So could you kindly stand up? Your matter is now postponed to the 27th of May 2022, back to court number 2 in Hillbrow, Magistrate's Court. You will remain in custody. However, your bail is fixed in the sum of 10,000 rands. If you pay the bail of 10,000 rands, you must report back to this court at 8:30 on the 27th of May, or else a further warrant of arrest will be authorized and issued against you, and you could return to custody. Do you understand, sir? Thank you.
as it is the court, worship. I'm not sure if the court is going to attend or.
Yes, the court will attend.
Right.